Okay, we'll now take up appearances. We'll start with Carolina Water Service. You're welcome. Welcome. 40 Love. Thank you, Ms. Valtorta. Welcome. Mr. Knowlton. And ORS. Thank you. Welcome. Welcome. All right. Do we have any preliminary matters to Mr. Nelson?
Chairman, if I could, there are a few matters I think that we need to probably take care of or resolve prior to starting the hearing. First, if I could lay out, there is a motion to strike the rebuttal testimony of Mr. Keith Babcock that was filed by the Office of Regulatory Staff and has yet to be ruled on. Secondly, I would like to move at this time to put the transcripts and exhibits of the original rate case into the record of this case, and I would ask that be, I guess, introduced as the first composite hearing exhibit in this case.
Okay, we'll introduce the transcripts from the original rate case as the first composite exhibit number 1.
Thank you, Mr. Chairman. Finally, I think we've resolved this, but just so that the Commission is aware that there are some confidential exhibits that Ms. Hipp filed. Just so you're aware of that, if we get to the point, I think Mr. Torini has agreed that because these are redacted legal invoices, that we can go ahead and use those on as necessary during the hearing. So back to the motion to strike, I guess, and I need to see if you want to hear from me or hear from the company first.
Yep, I'm here. Okay. Okay, if you'll get to the microphone, and we'll do that.
Customarily, at the end of rate cases, the Commission receives rate case expenses incurred by the company, and in this case, the ORS for expert testimony, and it is then audited by the ORS, and findings are submitted after the hearing. We have agreed that the best way we would propose for the Commission to handle that would be to allow the company to submit those expenses in its next rate case, subject to the usual procedure of audit and review.
Okay, it's fine. Okay, we want to hear from?
Thank you. And ORS is in agreement with Mr. Torini's last point.
Very good, thank you.
Just right. Briefly, I have about a 10-second argument regarding the testimony of rehearing rebuttal testimony of Mr. Babcock. ORS did withdraw the testimony of Steve Ham that we'd introduced in this. Mr. Babcock's rebuttal testimony specifically just mentions that the purpose of his testimony is to respond to testimony given by Stephen W. Ham, Esquire, for the Office of Regulatory Staff. And as his testimony only relates to rebutting the testimony of Mr. Ham, we would move to strike Mr. Babcock's rebuttal testimony.
Okay. All right, Mr. Scott Elliott.
Thank you, Mr. Chairman. While the stated purpose of Mr. Babcock's rebuttal testimony was to address the testimony of the ORS witness, expert witness, the question is, ORS witness Ham contends that CWS's defense of the Congaree Riverkeepers lawsuit was not undertaken to advance the interest of the ratepayers. Do you agree? While that was certainly Mr. Ham's position, it's also Ms. Hipp's testimony, and it's also Mr. Stangler's testimony, and so it's still very much an issue in this case. And so, but for this unforeseen last-minute withdrawal of their expert witness, we still have to litigate this issue unless Mr. Nelson is prepared to concede the issue.
Mr. Nelson, you have any response?
Honestly, I don't have anything else, Mr. Chairman. I think that's just our argument, is just that the stated purpose of the testimony is to address Mr. Ham's testimony, and it is no longer there, then we believe it is inappropriate and is moot and should be excluded.
We're going to grant the motion to strike. Thank you. Okay. We'll call on Carolina Water Service now to present the case. Yes. Correct. I have that in my notes and just went right over that. Thank you. Okay. How do we start? Opening statement. We'll go from the company first.
Mr. Chairman, I'll be brief. The Commission granted rehearing in this case on 4 issues. The Commission made specific requests for evidence on these issues. Carolina Water Service will answer each of the Commission's questions in this hearing, and I trust that we will satisfy any concerns.
Thank you. Ms. Valtorta.
Yes, good morning. I wanted to explain the presence of 40 Love Point. We're a neighborhood near Chapin that is served for water service and wastewater removal by Carolina Water Service. And over the past 10 years or so, we've found that a way to get improvements in our service is to intervene in rate cases, as we are doing now. In the past, we've been able to get pass-through water. We had wells to begin with, and now we have pass-through water from the City of Columbia, which means that our water is drinkable now. And in this case, we have intervened to address wastewater problems with our wastewater removal system. Before the first hearing, 40 Love Point had reached an agreement with Carolina Water Service, which I believe needs to be noted in any new order that comes forth that was in the original order. And that agreement is a short paragraph. CWS acknowledges that some of its customers in the 40 Love Point neighborhood have experienced problems with sewage backup. CWS has taken and will continue to take measures to address these customers' concerns. CWS and the HOA agreed to cooperatively investigate the source and extent of sewage problems experienced by customers in the 40 Love Point neighborhood and formulate a plan to address them. The company is retaining an engineering firm to perform an assessment of the 40 Love Point system, and CWS will continue to work with DHEC and Richland County to determine whether issues with the latter system may be affecting 40 Love Point. CWS and the HOA will report their findings to the Commission and the ORS in 6 months. And I think that last point is important because finally we have seen some improvements being done. There's work being done in our neighborhood. The engineering firm has sent people to our HOA meetings. And we want this work to continue because we do feel that it will improve, it will solve our problems. We've been trying to do that for about 4 years before this, and now because there's a rate case, we're seeing some action, and we would like to see that resolved. And so that is the point of our being here. We would like to have a supplemental hearing regarding this very short and toward the end of the year. Thank you very much.
Thank you, Ms. Valtorta. Mr. Nelson for ORS. Oh, sorry, Mr. Nolan. Thank you.
Thank you, Mr. Chairman. Just briefly, I'd kind of like to set the table for the Commission a little bit because, as Mr. Butler pointed out, there were 4 issues that ORS was granted a rehearing on. And first of all, I'd like to thank you for giving us the opportunity to discuss these issues one more time. You're going to hear testimony both from ORS and company witnesses regarding primarily 2 issues. And those 2 issues are whether or not the accounting practice of normalization was properly applied by ORS in adjusting CWS's sludge hauling expenses at its Friargate and Watergate wastewater treatment plants. And secondly, whether or not CWS is entitled to charge its ratepayers for certain non-rate case legal expenses, which ORS removed as being of no benefit to CWS's ratepayers. As to the EQ liner, the company has, subsequent to the initial hearing and order in this case, taken that EQ liner project and divided it into two separate projects. And in so doing, the remediation project is complete, and therefore ORS has no objection any longer to the company being able to recover those costs in rate base or put those costs into rate base. The only remaining issue there is about a $2,242 adjustment that ORS made to remove late fees and the cost of reinstalling the grass matting during the remediation. I don't believe the company has even contested these in their testimony. As to the fourth issue, that goes to the rate design. And ORS has reviewed and now understands the company's allocation of their increased revenue requirement. We do believe that there is an opportunity to maybe change the procedures a little bit, because what happens in water and sewer rate cases, as far as the orders and tariffs go, is a little different from the way the Commission typically handles electric rate cases. In those electric rate cases, there was always a requirement in the order that the company provide a tariff that complies with the terms and conditions of the Commission's order and file that tariff. And there was an opportunity for us, ORS, as well as the public, to review that tariff before it is then adopted and approved by the Commission. We don't go through that process right now in water and sewer rate cases. Typically, both the company as well as ORS will propose those rates in the order itself, and then once it's signed by the Commission, there's really no opportunity. We finally had the opportunity to get additional information from the company in this case. Based on our review of that additional information, we are satisfied regarding the allocation and the rates, so that issue really is off the table. I think that's all I have. Thank you, Mr. Chairman, Commissioners, for listening to me.
Thank you. Thank you. All right, now, Carolina Water Service. Yeah, we're going to have all the witnesses down front so we can look at you. Plus, that microphone works a lot better, and you don't have to sit right in front of Commissioner Howard. So.
Mr. Carton, would you state and spell your name for the record, please?
My name is Michael Carton, Michael Cartin.
And Mr. Carton, by whom are you employed and in what capacity?
I'm employed by Carolina Water Service. I'm the Director of External Affairs and Strategy.
All right. And how long have you been with Carolina Water?
About 4.5 years.
Thank you. Did you cause to be prepared and pre-filed with this commission 8 pages of direct testimony?
I did.
Have you had an opportunity to read your testimony before your appearance this morning?
Yes, sir.
Do you have any changes or corrections to your testimony?
I do not.
If I ask you those same questions today, would your answers be the same?
Yes.
Mr. Chairman, I'd move the direct testimony of Mr. Carton into the record as if given orally from the stand.
Okay, the direct testimony of Mr. Carton will be read into the record as given orally from the stand. Thank you.
And Mr. Chairman, if I may, I'd like to go ahead and get the rebuttal testimony into the record at this time before he begins his testimony.
Okay.
And so, Mr. Carton, did you cause to be prepared and pre-filed 7 pages of rebuttal testimony in this docket?
I did.
Have you had an opportunity to reread that testimony?
Yes.
Do you have any changes or corrections to your testimony?
I do not.
If I ask you those same questions again this morning, would your answers be the same?
Yes.
Thank you, Mr. Chairman. I'd move the pre-filed rebuttal testimony into the record.
Okay, Mr. Carton's pre-filed rebuttal testimony will be read into the record as given orally from the stand.
Thank you, sir. And Mr. Carton, did you cause to be prepared and pre-filed with your rebuttal testimony 3 exhibits, A, B, and C?
Yes.
Have you had an opportunity to reread those exhibits?
I have.
Any changes or corrections to your exhibits?
No, sir.
Chairman, I'd move the three exhibits, his rebuttal testimony into the record as the next hearing exhibit. I think two.
Correct. Mr. Carton's exhibits A through C will be entered as exhibit number 2. It's a composite exhibit.
Mr. Carton, the costs associated with the Friars Gate EQ basin remediation work performed by the company pursuant to a DHEC consent order is the subject of the rehearing in this proceeding. Briefly describe what the consent order required.
Required us to do a project which had 2 scopes of work, one scope being the remediation of the basin. Also, the second scope would be the repair of the EQ liner.
And has the remediation been complete?
Yes, it was completed in February of this year.
Have there been any other impacts to the remediation and repair project since it commenced in September of 2017?
Yes, in November of 2017, the company was notified by DHEC that the City of Columbia, as well as Richland County, had available capacity to take our flow from the Friars Gate wastewater treatment plant to their regional facility. This triggered a condition in our NPDES permit, which required us to interconnect with a local wastewater provider. In late February 2018, the company chose to proceed with the City of Columbia to interconnect with them, and they've provided us a letter of intent stating their intent to provide us an interconnection agreement.
And to be clear, Columbia is a regional provider.
Correct.
Now, what actions has Carolina Water taken in response to the city's letter of intent?
In March of 2018, the company hired an outside engineering firm, Goodwin Mills and Kaywood, to help advise us on our next steps for the repair phase of the EQ basin as well as the interconnection project.
All right, and have you continued to work with Goodwin Mills and Kaywood on this matter?
Yes, we have. GMC, CWS, and the City of Columbia have all worked collaboratively to finalize an interconnection agreement as well as to develop the scope of work required to complete this project.
Thank you. Will the any construction contract for the interconnection have contingency?
Yes.
What
The contract is contingent upon approval by this commission. It also required that the company get an amendment to the Central Midlands Council of Governments 208 Water Quality Management Plan. On August 23rd, the board approved an amendment that we had proposed. Basically, the amendment allows us to continue to keep the EQ basin in operation after the interconnection.
So to be clear, and what you're supplementing your pre-file testimony to say is that the 208 plan has approved the interconnection agreement with the City of Columbia?
Correct.
And is there pending now an application for this commission to approve the interconnection agreement?
Yes, there is.
When will Carolina Water seek to recover the costs of the interconnection project?
The company would seek to recover any costs associated with the interconnection, including repair of the EQ liner, in its next general rate proceeding.
Do you think that the interconnection agreement of the Friars Gate system with the City of Columbia is in the best interest of ratepayers?
Yes, I do. I believe the interconnection supports public policy of regionalization of wastewater systems, and I also believe that it ensures the company's ability to continue to provide reliable, cost-effective service to our customers.
Thank you. Now, the commission order granting rehearing asked you to update the sludge hauling expenses that the company has incurred. Did you do so, and is that in your direct pre-file testimony?
Yes, I did, and the chart in my direct testimony will show the company's monthly cost to transport sludge during the most recent period available.
Has Carolina Water's sludge hauling expense decreased since the rate case hearing?
Yes, it has.
Can you explain that?
Yes. Late in February of 2018, The company hired Clearwater Solutions to run the Friars Gate wastewater treatment plant in an effort to continue to optimize plant performance. And one of the major contributing factors to the decrease in sludge hauling expense was Clearwater Solutions brought a sludge press out to the site, which basically extracts water from the waste, which lowers the volume, and that's the main driver in the cost of sludge hauling. So the sludge press has been a contributing factor in Clearwater Solutions to the decrease in sludge hauling expense for the most recent period available.
Now, did Carolina Water's decision to outsource maintenance of the Friars Gate plant increase or decrease your O&M?
It increased our O&M by approximately $20,000 a month.
Is the company seeking to recover its increased O&M costs in this proceeding?
No, it is not. Just like the decrease in the sludge hauling expenses, the increase in O&M due to the Clearwater Solutions contract was outside of the test year, and it was not known and measurable at the time of the application.
Now, how much in litigation costs is the company asking this commission to authorize it to recover in this proceeding?
CWS is seeking to recover a total of $992,000 over 66 2/3 years. This equates to an annual revenue requirement of $14,894. The company is not asking to recover a return on these costs, just a return of.
All right, and I think the original amount in the commission order was approximately $998,000. Can you explain the difference?
Yes, there were 3 invoices which were improperly coded to this project, so the amount was lowered by about $5,600.
Did you break down the I-20 litigation costs by case in your direct testimony?
Yes, I did. There's a table in my direct testimony which lists the different legal proceedings and the costs incurred associated with each proceeding.
And is Carolina Water providing testimony in this case in support of the reasonableness of its I-20 litigation costs?
Yes, witness Babcock will be testifying to the reasonableness of the fees in this case.
Thank you, Mr. Carton. May I direct your attention, please, to your rebuttal testimony?
Yes.
And what is the purpose of your rebuttal testimony in this document?
To address issues raised in ORS witness Hipp's direct testimony.
Do you agree with Ms. Hipp that CWS's updated sludge hauling costs support their normalization adjustment?
No, I do not. The company's sludge hauling costs cannot be viewed in isolation. While they have been lowered since the April 3rd, 2018 hearing of this year, we've had many other expenses, such as contract operations, for instance, which have increased by approximately $30,000 a month. I believe that the rate case should be based upon test year expenses.
Does the ORS attempt to cherry pick costs in support of its position?
It looks that way when they just use just one expense item, sludge hauling, to lower the revenue requirement in this case.
In fact, that's your testimony in your pre-file testimony.
Yes.
Should the Commission accept the ORS's normalization adjustment because CWS will not incur sludge hauling costs when the Friars Gate plant is replaced by an interconnection with the City of Columbia?
No, for several reasons. At the earliest, we anticipate the interconnection with the City of Columbia to be complete at the end of the first quarter of 2019. CWS hopes to obtain this Commission's approval for the interconnection agreement on or before October 1st of 2018. So it has not been approved yet. That's one reason. But most importantly, the elimination of sludge hauling expenses due to an interconnection is a change that will happen in the future. And I believe that if the Commission were going to look forward at expenses as a reason to make an adjustment, it needs to do so comprehensively and look at all predicted expenses in the future.
Well, in your pre-file testimony, you mentioned that your purchase sewer expense might increase if this is approved. Can you explain your
Yes, I believe I mentioned in my rebuttal testimony that if they were going to remove sludge hauling expenses at Friars Gate because of a future pending interconnection, that they should also take into account that when we interconnect Friars Gate, if and when we interconnect Friars Gate with the City of Columbia, our sludge hauling expense will go away, but we'll immediately be incurring purchased sewer expense. Right now, our numbers show in about the tune of $1.2 million annually in increased purchasing sewer expense after the interconnection.
All right, thank you. Ms. Hipp asserts that Carolina Water did not dispute the ORS normalization of the Watergate sludge hauling numbers. Is she correct?
No. CWS sought and obtained recovery for the combined cost of sludge hauling at the Watergate and at the Friars Gate wastewater treatment plant.
How do you respond to Ms. Hipp's argument that the recent reduction in Carolina Water's sludge hauling costs confirms that the test year costs were abnormally high?
As explained in my direct testimony, CWS took affirmative measures to reduce its sludge hauling expenses and optimize our plant operations. Specifically, it rented a sludge press to reduce the volume of sludge being transported.
Now, turning our attention to litigation costs, Ms. Hipp proposed an adjustment to remove about $20,000 paid to a firm, Winston & Strawn. Do you agree with that adjustment?
I do not. While Ms. Hipp testified that ORS could not verify the work performed by Winston & Strawn was related to the Riverkeeper case, the language on the invoices reveal the opposite. I've attached a declaration from the firm, Winston & Strawn, as an exhibit, declaring that the work that they performed was in fact related to that case.
Good. Thank you. Now, Ms. Hipp proposes removing about $87,000 for advances and expenses invoiced by Willoughby and Hafer for various consultants and advisors. Do you agree with her adjustment?
I do not. Mrs. Hipp's recommendation was on the fact that we did not provide any vendor invoices for the various expenses, and we did not assign them to specific litigation. I do not believe that anyone questions whether the advances or the expenses were incurred as part of the litigation, and I've provided copies of the disputed invoices relating to the advances as Exhibit B to my rebuttal testimony. As clearly shown in my exhibits, these costs were incurred as part of the cases which are listed.
Ms. Hipp proposes removing about $156,000 for legal services performed by Willoughby and Hafer where the description of the legal work was redacted. Do you agree with that adjustment?
I do not. Redactions to the invoices were necessary because they involve ongoing litigation, and it will protect privileged information and attorney work product. It was necessary to redact these invoices before providing them to ORS.
In her direct testimony, Ms. Hipp proposed to remove about $92,000 associated with the EQ remediation work done at Friars Gate. Do you agree, and would you mind just updating your testimony with the light of Mr. Nelson's open argument? That matter largely resolved.
Yes, the parties both agree that the invoice referenced for approximately $90,000 was not associated with the EQ remediation project. It was associated with the collection system work that we were doing at Friars Gate. The company would respectfully request that the commission approve this invoice and include it as part of the collection system work, which was consistent in the original order.
And if the commission were to accept the ORS and the company's agreement here, the revenue requirement overall would remain the same on the sewer side, correct?
Correct.
Describe briefly what steps Carolina Water is taking to address the sewer service concerns of the Dixons, Kings, and Wagners in 40 Love.
As I mentioned earlier, we're working with Goodwin Mills Kaywood, or as we call them, GMC. We've hired GMC to be on site and provide short-term and long-term solutions to the issues at 40 Love Point. And in the interim, while they continue to aggressively work to remediate these problems, we have suspended sewer service charges for those 3 customers whose homes were affected.
And isn't it the case that Mr. Laird of the engineering firm is testifying on this matter this morning?
That is correct.
Thank you, Mr. Carton. Would you please answer any questions the parties have or the commissioners may have?
Yes.
Okay, thank you. Ms. Valtorta, any cross?
I just have one question for Mr. Carton. Are you in agreement that we will have a supplemental hearing on the situation at 40 Love Point with the wastewater system toward the end of the year or in January of 2019? Is that your understanding?
No, that's not my understanding. My understanding is we're going to continue to be present in your neighborhood, speaking with the homeowners. We have our engineers that are attending all the HOA meetings. So I don't recall a supplemental hearing, but we will be in constant communication as we have been as we continue to work through the problems.
Yes, we appreciate the steps that have been taken, but the agreement mentions that we will, at the bottom of it, it says we will come back for a short supplemental hearing in 6 months, and that was in May.
We are to provide the commission with a report updating them on the progress of the work done, which is due September 30th, and the company will be providing a comprehensive report on the short-term, long-term solutions and the work that's been going on at 40 Love.
Would you be opposed to a short supplemental hearing here at the commission if we were to move for it?
I'll look at my attorneys there. I'm personally not opposed, no ma'am.
Okay, thank you.
Thank you, Ms. Valtorta. Mr. Knowlton.
Thank you for your testimony, Mr. Carton. I just wanted some clarification on one thing. Did I understand you to testify that when the sludge hauling is stopped due to hookup to Columbia sometime in 2019, that you expected expenses to increase then?
Yes, sir.
So it costs less to sludge haul than to commercially process is basically what you're saying?
Sludge hauling is just one expense associated with the operations of the Friars Gate wastewater treatment plant. What I was saying is when we interconnect, we'll no longer have to remove sludge every month because we'll be sending wastewater, untreated wastewater, to Columbia's regional facility. So we won't be treating the wastewater anymore. So our O&M for purchase sewer expense will go up. We call it purchasing sewer expense, but it's the flow that we'll be paying to the city of Columbia every month.
Thank you.
You're welcome.
Thank you, Mr. Knowlton. ORS.
Morning, Mr. Carton.
Morning, Mr. Nelson.
Oops, sorry, didn't mean to hit that button. Mr. Carton, you had just provided some testimony where you said that ORS was cherry picking. Can you explain again what you meant by that?
Looking at one expense item in isolation.
Isn't it in fact true that what the commission ordered in their order on rehearing was that, quote, at rehearing, CWS should update sludge hauling expenses for the most recent period available and provide on a monthly basis the amount of sludge hauled and the cost of transporting the sludge? Wasn't that part of the order?
It was.
Okay, so the commission did not order ORS or CWS to update any other expenses, did they?
That's correct.
Okay, so by saying ORS is cherry picking, what ORS was doing was complying with the commission order. Isn't that true?
I was referencing to the original direct hearing where y'all picked one expense item.
So we're not cherry picking anymore.
Sure.
Now, is it your understanding that ORS typically updates pro forma and expenses which are outside the test year that the company chooses?
Yes, there's an audit cutoff date. I work closely with the ORS's audit group, and there is a pro forma plant up to this year was February 12th, and known and measurable expenses are typically accepted.
So things like increases in salaries from the company can be updated so that they're annualized then?
Yes.
Right. ORS also allows pro forma adjustments to purchase water, correct?
Correct.
So when we talk about the normalization here, isn't this just another, annualization, or isn't this just another adjustment to try and make the figures actually represent where the company is at the time of the hearing?
I believe that's what ORS was doing in their adjustment.
Okay.
And when you reference these updated expenses, my issue is that they're outside of the test year. They're well past the audit cutoff date. And so in my direct testimony, what I was trying to say was that to not look at it in isolation, because yes, our sludge hauling expenses have decreased. The company's always looking for ways to optimize plant performance and lower expenses when it can. But the recent period available was February of this year up through, I believe, June of 2018.
So do you have a problem with the normalization then? Is normalization a process or an accounting procedure that CWS recognizes as a legitimate regulatory principle?
I do recognize it. I was just saying in this case, we believe that we were entitled to our known and measurable test year sludge hauling expenses, as if we were going to continue to have them for the foreseeable future.
We just don't take your known and measurable salaries as of the cutoff date, do we? As of the test year date? I mean,
Right.
we allow you to update things, right? To your advantage, we allow you to update certain things, true?
That is correct.
So, but we're not allowed to any disadvantage to the company to update expenses. Is that what you're saying?
No, ORS is allowed to propose whatever they would like.
And I go into litigation costs issue now. Is the condemnation case concluded yet?
It is not.
Isn't it true that if you win that case, that if CWS prevails in that case with their valuation over the town of Lexington, that the company will be entitled to recover certain legal fees from the town?
That's my understanding, but I would direct that question to witness Babcock.
But you're asking to recover those costs now from ratepayers too, is that true?
That's correct.
What about the permit issue at the Administrative Law Court? Is that still pending as well?
I would ask that question of Mr. Babcock. I believe he's the best to answer this question.
As far as you know, the permit issue, though, is still, I mean, you're aware of the operations of the company, the permit. You still don't have a current permit. Is that true?
Correct.
Okay. I'm going to show a couple invoices here, Mr. Chairman, that have been submitted by Ms. Hipp, and they're part of her confidential exhibits. But my understanding, and again, I'll let Mr. Torini interject if he needs to, but my understanding is that because these are redacted, that they have no objection to my using these, so I wanted to ask Mr. Carter questions about them. Sorry. Cell phone. Sorry. Okay, Mr. Carton, on permission to approach the witness. Mr. Carton, I want to ask you some questions about, and if you can turn to page 5 and 6, I think, of your rebuttal testimony. Is it part of your contention in this testimony here that it was ORS's responsibility to ask for sufficient support for your expenses? Is that the position y'all taking? Sure. What I'm saying is, did you say ORS was responsible for trying to verify these expenses? Isn't it, in fact, the duty of the utility to prove?
Yes.
Okay. And was it also your position that ORS is the proper party to try and determine the scope of the work or what case this work was done on?
The ORS is charged with the duty to audit and examine our expenses.
And it's your duty then to provide those expenses in response to the questions, right?
Yes.
Yeah. Okay. I'm going to hand you something. This is rehearing exhibit DMH4 confidential on this page, starting at page 34 and through page 41 of Ms. Hipp's exhibit. I just want to go through a few of these here and where you can see the yellow portions that I've highlighted in yellow. And for this particular case, this is on page 35 of 113, and this is dated 03/05/2016. Can you read for the commission what that entry is for?
Email.
Yeah, yep, the yellow one.
Email with David Peterson in response to a blank redaction subpoena.
Can you tell me what case that is for?
I cannot testify to it, but I worked closely with our attorneys that worked on this case to just help tally the expenses for which they were incurred for each case.
Okay, and how is ORS supposed to be able to determine what case that went to when that's the information we're looking at?
I think it's fairly clear by looking at the entire invoice who was working on the case.
Which case, though? Isn't, in fact, these invoices cover numerous cases on a lot of occasions?
It is. We had, affirmation from the attorneys who did the work about the work in which it was performed line by line, but it was my understanding before I provided these invoices to ORS that they accepted that redactions would have to be made to protect attorney-client privilege. I was under the understanding that ORS was okay with that, and so we were just not expecting to throw out expenses due to just redactions.
What's your understanding? Because I believe you were asked a question on direct here about the reasonableness of expenses. Is it your understanding that ORS is in any way contesting the reasonableness of any of these expenses?
I'll defer to Witness Babcock on that question.
Let me have you read one more for me. I've got several here, but if you could read this one, and this is, I don't have a date, CNJ. You could read either one, read that one right there, which is CNJ, and this is on page 36 of 113 of Ms. Hipp's Exhibit 4. Yeah. Sure. I've got it here. Mr. Elliott. It's page 3, or rehearing exhibit DMH4 confidential, page 36 of 113. Third line down, CNJ entry. Can you read what that is, please?
Revisions to a redaction based on comments internally from blank counsel, drafting a cover letter for the same oversight, serving of the same review of correspondence between John H. and DHEC, setting up a meeting.
And which case is that referring to then?
I don't have my notes in front of me of which my attorney told me which case it was for. I looked at his line by line, but I don't have all that information with me, so I can't state which case.
So you can't state by reading that language, you can't tell what case it goes to, can you?
I cannot.
Okay. And there was also specific mention of the Winston and Straw invoice, I believe. I'm going to show you now what's been marked as a rehearing exhibit DMH2 confidential, page 2 of 18. And can you tell me where on that invoice what litigation is referenced, or how it is supposed to be determined from that invoice what case it's for?
For one, we provided a declaration from Winston and Strawn telling everyone exactly what it was for. From looking at this invoice, just with the timing of it, the people involved, and who they were working with, Utilities Inc. litigation during this time period, I think it's a pretty fair assumption to assume that it's part of one of the ongoing I-20 litigation cases.
But there's nothing on this document on its face that tells ORS when they saw it what case it went to, right?
In my opinion, I would read it and say, Utilities Inc. ongoing litigation with the firm representing us on that case. To me, that lets me know that it's part of the Congaree Riverkeeper case, but I could see where ORS would maybe have an issue with that.
Has the Congaree Riverkeeper case concluded yet as well?
It is not.
And going back to the Winston and Straw, when in fact did you provide the statement from the firm or whatever we were talking about, the verification?
That was in my rebuttal testimony.
Okay. That's the first time you provided that to ORS, is that correct?
That was the first time I provided the declaration, correct?
All right. I think I'm done. Thank you very much, Mr. Carton. I appreciate it.
Thank you, Mr. Nelson.
Thank you, Mr. Nelson. Commissioners. Mr.
Chairman.
Williams.
Thank you, Mr. Chairman. Sir, on page 3 of your corrected pre-file rehearing direct testimony, you state that the company expects to execute.
A little closer to that mic there, Commissioner.
On page 3 of your corrected pre-file hearing direct testimony, you state that the company expects to execute a contract for the Friars Gate wastewater facility interconnection project in late August or early September. Has that contract been executed as of today?
Yes, we have executed the contract with the City of Columbia, and it is now waiting Public Service Commission approval. So it's not fully executed until it requires Commission approval to move forward with the interconnection agreement.
Thank you.
Welcome.
Mr. Elam.
Good morning, Mr. Carton.
Morning.
On page 4 and 5 of your corrected pre-filed rehearing direct testimony, you have a couple of charts showing sludge hauling expenses, and it shows, I guess on page 4, that shows a declining set of costs month to month. Can you explain why there's the difference between February and March?
Yes, after February, we completed the remediation project, and sludge hauling expenses went up right after that, and we hired Clearwater Solutions at the end of February. They came in early March, and one of their recommendations was to bring in a sludge press to extract water from the waste, which resulted in these lower, more flat sludge hauling expenses moving forward.
Okay, were the expenses prior to February, where were they? Were they consistent at that $100,000 level, roughly, or?
They were lower than that. We were averaging about $20,000 to $30,000 a month, and this was just coming right out of the remediation project, so volumes were a little higher coming out of there. That's my understanding of the project.
I was just going to say, why was it that much higher?
I'm not sure.
Now, Watergate, that shows a decline from February through April, and then it shoots back up in May and then starts going back down in June. What's the cycle about? Or is that?
It depends on how much sludge the plant is outputting, so there's a lot of external factors. You know, I'm not the expert on it, but I know when it rains a lot more sludge is produced, things like that.
In your opinion, can changes in costs that occur outside the test year be an indication of future expenses?
Sure.
On page 3 of your rebuttal testimony, you say that at line 11, you say Ms. Hipp advocates punishing the company for undertaking measures that increase its operational efficiency. You think ORS is punishing you as opposed to just trying to establish what a normal number going forward is?
What I was trying to say was that we've implemented processes which optimize performance and lowered sludge hauling expense. It's one expense that went down. I also mentioned other expenses which went up. So when I say punishing, meaning not allowing us full recovery of test year expenses, because the costs have gone down in the most recent period available, which was 8 months after the end of the test year or so.
If costs go down and it's known and measurable, are you saying that should not be adjusted?
I'm saying that if the commissioner is going to look forward which my charts show us looking forward starting in February of this year. Our test year ended August 31st, 2017. It should look at all future expenses, not just sludge hauling.
During your testimony with responding to Mr. Elliott, you said something about a $30,000 increase in cost. Was that an annual or a monthly?
Monthly for our contract operations at Friars Gate.
And is that with who?
Clearwater Solutions.
What was the, you said it's at Friars Gate?
Yes, sir.
And that's saving you money over what you would have done had you just continued handle sludge in the same manner you had.
It was Clearwater Solutions' recommendation to bring in the sludge press.
And that resulted in a lower monthly.
For sludge hauling, correct. While contract operations went up, sludge hauling went down.
Okay. You're going to connect with the city of Columbia from, I guess it's Friars Gate, correct?
We hope so.
Okay.
Sir.
Why the city of Columbia? Was that just the closest interconnect?
There's a lot of reasons, but we worked had meetings with Richland County and the city of Columbia, and Richland County did not provide us with a formal proposal and a letter of intent, and the city of Columbia did.
Was it the closest interconnect?
Oh, it's much more easier construction. Our current effluent line actually crosses over the city of Columbia's line, so it makes sense rather than having to build a 4-mile or whatever interconnection it would be to tie in with Richland County. But we're required to meet with both and discuss the options with both and then make the best decision for our customers. And we believe moving forward with the city of Columbia was the right choice for all parties.
That's all I have, Mr. Chairman. Thank you.
Thank you. Commissioner Howard.
Thank you, Mr. Chairman. Harlan, page 9 of your corrected pre-file rehearing direct testimony, you presented a chart showing cost summaries of litigation by the legal action. Was this information available for use at the original hearing?
It was not. We had not broken it out by case in the original hearing. We had it all in one project, which we had labeled I-20 litigation, and that's what we presented at the original case.
So it wasn't. Let me ask you another question. What advantage is to the ratepayers to maintain the EQ line after an interconnection agreement?
So I mentioned earlier we went to the COG, the Council of Governments for the Central Midlands area, and we had to get an amendment to keep the EQ basin in operation because when the City of Columbia made their proposal, they had asked the company to keep the EQ basin in service to manage peak flows. So if they have a ton of flow on their side, or it's really to manage, we have a 1.2 million gallon that we're allowed to give to them each day, and this equalization basin serves to equalize the flow that goes to City of Columbia, so we don't just give it to them all at once, basically. That was part of the agreement with City of Columbia.
I see. Thank you very much.
You're welcome.
Thank you, Commissioner Howard. Commissioner Whitfield.
Thank you, Mr. Chairman. Mr. Carton, I've got one question for you, and Commissioner Elam kind of all but went down this path with you, but just real briefly, if you could turn to page 2 in your rehearing rebuttal testimony. I'll give you a second to get there.
I am there. Thank you, sir.
Okay. You state that the commission has never set rates based on a future test year, and that if the commission should decide to, quote, look forward, that we must do so comprehensively. My question is, if the company and ORS have proposed pro forma adjustments to the historical test period, in other words, a blueprint, if you will, for the historical test period, would you not consider those pro forma adjustments to be forward-looking?
What I was saying was they referenced that sludge hauling is going to go away in the future.
Right.
Because of the interconnection. So I was saying if we are going to look forward, when I say future test year, I mean outside of the test year, what's known and measurable in the test year, and then up to an audit cutoff date period. At the earliest, we hope to have an interconnection with the City of Columbia at the end of the first quarter of 2019. That's so far out. So I was going to say, what I was trying to say was that if the commission was going to look forward based on the recommendation that we're going to have zero sludge hauling cost at Friars Gate after the interconnection, I was asking in particular, if you're going to take into account for that reason that it's going away if the interconnection, should also assume the cost that we're going to have, that it'll increase when the interconnection goes away for purchase sewer expense. That's what I was really trying to convey in my message, was to look at the other costs that'll go up with the interconnection, not just the costs that are going away.
Right, and I think you explained in an answer to another person here today that that maintaining that plant, that sludge hauling is just one of the expenses involved with operating Friars Gate. And
that's correct. Yeah, certain costs will go away, certain costs will go up. I mean, testing expenses we anticipate to go down because we'll be sending raw wastewater rather than effluent. So that's just an example of a cost that would go away. Testing would go away, purchase sewer expense would go up. But yeah, there's a lot of different expense items at that plant.
For treating, yes.
Correct.
You had an exchange with Mr. Nelson about normalization. And so based on my first question here to you, could you repeat maybe your opinion on normalizing those costs, since you have explained there, of course, a lot of that's going to go away, but talking about the cost during the test year being so high, could you maybe reiterate your position on normalization?
My position is that our sludge hauling expenses during the test year and up through the cutoff period was known and measurable test year expenses that are going to continue for the foreseeable future. And that's really all I was saying, is that these costs are known, measurable, and they're going to continue for we don't know how long. We obviously hope the commission approves the interconnection with the City of Columbia. It aligns with our position on public policy of regionalization. We think it benefits all stakeholders, but all I was trying to say was that these shouldn't be viewed in isolation, and that it's known and measurable test year expenses. We'll continue to have these expenses moving forward. And so I didn't think for this instance normalization was correct. That was just my position.
All right. Thank you, Mr. Carton. That's all I have, Mr. Chairman.
Commissioner Irvin.
Thank you, Mr. Chairman. Mr. Carton, on page 8 of your pre-filed direct testimony, you present a table that lists the cost associated with the company's I-20 litigation. And I believe they're listed by legal action. Are these costs all related to the I-20 litigation?
As I state here, there's multiple cases going on. So what we did was I sat with our attorneys and was able to break out expenses by case. So it's multiple cases. You know, originally in the last rate case, we provided them as just I-20 litigation expenses. We did the same thing here in this case. And then for this rehearing, the commission had asked to break them out by case, which is what I've done here.
Thank you.
Thank you.
Okay. Commissioner Hamilton.
Thank you, Mr. Chairman. Carlin, how are you today, sir?
Good, thank you.
Been with us here for a while now.
Yes, sir.
Make the
I appreciate it.
on your contract with the City of Columbia, is it a set price contract or is it a volume?
It's based on our flows. We were able to negotiate, to my knowledge, the lowest outside of the city rates cost that has been given on a bulk contract with the City of Columbia. So we'll be paying for wastewater flows what in-city customers pay plus 5%, which was approved by the Columbia City Council. It is subject to City of Columbia rate increases. Right now, it's based on our volumetric flow.
It appears from the test year that we've been looking at in this case that the amount of sludge has increased due to a lot of storm water that you're having to treat. Has this been a problem that you've experienced?
We are working right now to tighten up our collection system through I&I work, which will lessen the flows that come through. I'm not sure I understood your question, but we are, stormwater does, I've been told, can increase sludge because more water is being pushed through the system.
You got to treat all the water that.
Yes, we have to treat all the water that comes through, and sometimes stormwater does get it.
Waste of money to treat stormwater.
Yes, sir, which is why we continue to invest in our collection system and the repairs in the collection system annually.
And the water that you get from the press after you don't have to haul sludge, but you have to treat that water also.
That's correct.
So you're not having to haul as much sludge, but you're having to treat probably more water now.
Correct. Correct. And then after the interconnection, just to be clear, and then if and when we interconnect, all that we need to tighten up our collection system to stop stormwater intrusion, because that'll lower our O&M because we'll just be paying for the flow. We won't be sludge hauling and extracting water from waste before we send it to the city's regional wastewater system.
That would be a recommendation that I feel would help ratepayers in discussion that we've had about sludge.
Yes, sir. You're exactly right. It'll put even more emphasis on us to invest in our collection system after the interconnection.
Very good. Thank you, Mr. Carr.
Thank you.
Thank you, sir. Commissioner Howard, do you have another question?
Thank you. Mr. Carlin, how do you tighten up your collection system, and why hasn't it been done before?
It has been done before. In this case, there was a lot of money invested in our collection system, and it's something we continue to do. Maybe Witness Laird, our engineer, can talk about the specifics of how you tighten it up. But, sometimes lines split. These lines, particularly in Friarsgate, are decades old. So we go through and camera all the lines and find where maybe there's stormwater intrusion or where repairs are going to be made. Then we prioritize it based on a cost-benefit analysis, what work makes the most sense. Also, while managing the impact to our ratepayers, we can't just fix everything at once and spend that much capital. So try to make investments in the best place possible. But it's an ongoing process, tightening that collection system, and we continue to work on it as we worked on it in between the last two rate cases.
I'm not sure I understood you, but did you say there was $1.2 million, 1.2 million gallons a day in your contract?
Correct. We're not supposed to exceed 1.2 million gallons of flow per day to the city's Columbia regional wastewater system. That equalization basin will help.
Historically, in the past, what would be your average?
I'm not sure the average, but the company feels confident that we can meet that 1.2 million gallons and not exceed it moving forward. And the EQ basin will be vital to making sure we don't exceed that amount.
Okay. Thank you.
Thank you. Commissioner Whitfield.
Thank you, Mr. Chairman. I had a follow-up for you, Mr. Carton, related to where Commissioner Hamilton was questioned, but I think Commissioner Howard may have gotten close to that too. It's fair to say, of course, that sewer plants, whether by yours or the cities, they're designed to meet capacity at the time of need. So you mentioned in your answer to Commissioner Hamilton that you'd be charged on flow, and I think you said you thought that it was one of the lowest out of the city bulk contracts negotiated, I believe you said.
Yeah, to my knowledge, for an out-of-city customer to be charged an in-city rate plus 5%, to my knowledge, that was a very good rate, something we were very pleased with to negotiate. It started much higher.
And you also touched on this, but I just want to kind of get it back on the record again. You also, and Commissioner Howard just mentioned those limits, part of your arrangement is you have to be able to, not only are you charged by the flow, but you also have to be able to, quote, manage the flow so that you're not putting too much in at one time.
That's correct.
And was that one of the ways you were able to negotiate the arrangement, the deal that you did, so to speak, with the city?
Yes, sir. It's part of the requirement from the City of Columbia that we keep the EQ basin in operation. It just now serves a different role than it did before when it was
Right.
a treatment facility. But it was part of the deal was that we had to continue to use the EQ basin to manage peak flows and equalize flow, so it doesn't all come at once. The city receives it.
Thank you for that, Mr. Carton. That's all I had, Mr. Chairman.
Thank you. Okay, just one quick question. No, I&I is a problem for everybody that's got pipes in the ground in the whole world. But one more sludge question. Sludge press is an interesting piece of equipment, an expensive piece of equipment. Did you ever, before you set up the while you were still hauling sludge, did you ever? And I don't know if you even can rent a sludge press. Did you ever consider a rental of a sludge press back in before all the other action you took to reduce your cost?
CWS, or Carolina, it's funny because Clearwater Solutions is CWS, but Carolina Water Service did not. It was based on the recommendation of Clearwater Solutions when they came in as a way to optimize the plant and control costs. It was Clearwater Solutions' idea, and we do rent the sludge press. We did not purchase it.
Okay, so you are renting it.
That's correct.
I got you. Okay, that clears that up. All right, commissioners, anything else? Yes, Commissioner Elam.
Curiosity, the contract with the city to manage flow and I guess to control peaks, is it that you would hold water in the basin and it would be pumped off peak hours, or what is the basis for the lower rate from the city?
That's not the basis for the rate, but it was just part of the agreement because City of Columbia didn't want us, typically in the morning when people are getting ready to go to work, flow's real high. We didn't want to send it to them all at once. Also, when people get home from work and they're washing clothes, doing the dishes, all the flow come at once. So the City of Columbia, in an effort to manage it and finalize the agreement, they had asked that we keep the EQ basin in operation, just in a different role, which requires, as I said, PSC approval, as well as an amendment to the Central Midlands COG 208 plan. Thank you.
All right, Mr. Elliott, any redirect? Do we have a choice?
Now, Mr. Carton.
Sure, you cut it on.
Well, I'm in a hurry, Mr. Chairman.
Don't want to put any undue pressure on you.
Mr. Carton.
Sir.
Much better.
Thank you. Now, Mr. Nelson asked you a number of questions on cross-examination concerning the normalization concept in rate making. Do you recall that?
Yes, sir.
And what it may not be clear from your direct or rebuttal testimony, but I suspect Mr. Nelson felt comfortable asking you questions of that nature because you had actually worked at the ORS previously in your career, correct?
I did, yes.
And you are familiar, as a consequence of your work with the ORS and your work with Carolina Water Service, with rate-making concepts, correct?
Correct.
And you've appeared before this commission on behalf of the Office of Regulatory Staff concerning.
Agree.
So have you appeared before this commission?
I have.
On behalf of the ORS?
I have.
All right. Now, are you familiar with the regulatory concept that provides that utility costs and expenses are presumed reasonable?
Yes.
And in this case, would that rate-making principle apply to litigation costs?
Yes.
And in this case, would that principle apply to sludge hauling costs?
Yes.
Now, are you familiar? You testified a little bit about the importance of a test year concept. Do you recall that?
Sir.
Mr. Nelson asked you questions about that concept.
Correct.
And what is, just in your own words, and very briefly, describe the concept of a test year in terms of setting rates?
In South Carolina, we use a historical test year to base rates, and we make known and measurable pro forma adjustments to test year expenses and capital to base rates off of going forward.
All right, and when in making those known and measurable adjustments, does the ORS, as a matter of practice, set a time limit on when it will allow those known and measurable outside the test year adjustments to be made?
They do.
And in this case, in chief, the rate case, what was that date?
February 12th, 2018.
And as a part of your responsibilities with Carolina Water, did you work with Ms. Hipp and Mr. Sullivan and Mr. Schellinger and Mr. Payne in providing them known and measurable expenses outside the test year?
Yes.
And in so doing, you provided your sludge hauling costs to the ORS as a part of this rate case.
Yes, I provide them all of our books up through the cutoff date.
And what the ORS proposed
we need you at a microphone, Mr. Nelson, please.
Renew the objection, Your Honor.
Okay, we just sustained that, and so we need for you not to lead the witness.
And so what the commission found in its order was that did the commission find in its order that that the company incurred known and measurable sludge hauling costs?
I think I'm going to overrule that. I think he's asking a question now.
Could you re-ask the question?
Maybe not. Did the commission in its order approve known and measurable sludge hauling costs?
Yes, it did. The commission sided with the company's position in the last rate case that we were entitled to the sludge hauling expenses incurred during the test year of September 1st, 2016 through August 31st of 2017.
Thank you. Now, Mr. Nelson asked you questions concerning the Winston and Strawn invoices?
Correct.
Did you submit, on behalf of Carolina Water, did you submit the Winston and Strawn invoices to the ORS for their review?
Yes.
And to your knowledge, did the ORS make an effort to review those invoices?
I believe so, yeah. They did make an effort to review the invoices.
And what's the ORS position on the invoices?
That they could not verify that they were a part of the case, of the CRK or Congaree Riverkeeper case, so they should not be allowed for recovery in this case.
Now, when you submitted the Winston and Strawn invoices to the ORS, did you also submit Willoughby and Hafer invoices?
Yes.
And to your kno-
Oh, I'm sorry. I gave them all invoices, which totaled the amounts in my testimony.
And has the ORS, to your knowledge, had an opportunity to review those invoices?
They have.
Now, let me show you, I think Mr. Nelson referred you to page 35 of 113 in the HIP Exhibit 4, and I show you that page and ask you if you recall his asking you a question from that page.
Yes, I recall.
And do you recall which entry he asked you about?
I believe it was this one on March 5th, 2016.
And read it, please.
Email with David Peterson in response to subpoena.
All right. Now, do you see anywhere else on this Hafer invoice, Willoughby and Hafer invoice, where Mr. Peterson's name might be mentioned? And I might draw your attention to the date 3/3/16.
On 3/3/16, an attorney, Mr. Lowell, had a telephone conversation with Dave Peterson in response to a subpoena to review the subpoena objections and emails, and review emails, and I had a conference with John Hafer and Chad Johnston in response to the subpoenas, scheduling orders, and DHEC's emails with the Southern Environmental Law Center.
So, would a ORS review of this page reflect the identity of Mr. Peterson?
Yes.
Let me draw your attention, if I may, please, to page 7 of 18 of Rehearing Exhibit DMH2. And ask you if you recognize this invoice.
Yes, I do.
And what is this invoice?
It's a Winston and Strawn legal invoice.
All right. And let me draw your attention, if I may, to the entry for 3/3/16, and let me ask you to read that entry, please.
On 3/3/16, Attorney Wolf spent 3 hours to revise objections to Utilities Inc. subpoena and had correspondence with R. Lowell in response to the same. Phone conference with Johnston in regards to the same, and correspondence with M. Melbringer and L. Desrady in response to the subpoena status.
All right. And
If I pronounce their last
the
name.
R. Lowell, do you recognize Mr. Lowell's name?
I do.
And who is he?
He's an attorney at Willoughby and Hafer.
And C. Johnston, do you recognize that Willoughby and Hafer lawyer name?
I do.
And who is he?
He's an attorney that's been working on this case with us.
Now let me go back, if I may, please, to page 35 of 113 of Rehearing Exhibit DMH4. We've looked at this. You've looked at this now twice. I'd ask you to look at it a third time. And in particular, I'll draw your attention to an entry under 3/3/16 and ask you to publish that, please.
C&J, which is Chad Johnston, the attorney at Willoughby and Hafer, had a phone call with Kevin Wolf of Winston and Strawn in response to a draft of objections to a subpoena. Revisions to objections based on the same put into a formal pleading format. Revisions to cover letter for the same. Recirculate to the team for review. Review of draft of proposed scheduling order draft by CRK.
And just to be clear, does the entry you just read from Mr. Johnson correspond to the entry from Mr. Wolf of the same date?
Yes, it does.
I ask you again, Mr. Carton, do you think the ORS reviewed these invoices before they appeared here today?
I believe they did review them, yes.
Now, Mr. Nelson cross-examined you about the format of the invoices you submitted. Do you recall that?
Yes, sir.
Does Carolina Water have a practice of submitting its invoices to the ORS for review in rate matters?
Yes.
And what is Carolina Water's practice with respect to submitting invoices from its attorneys?
I would take I'll get a data request, typically from Jay Jasinski's group, Mr. Jasinski, or Ms. Hipp's team, and it'll have a request for invoices. It's very common. We always provide all invoices that they request. And in particular, with legal invoices, I will let my legal team review them. And in the past, I have seen them sometimes provide redactions to protect attorney work product.
Was that the case in the 2015 rate case?
Yes, sir, I believe so.
You provided the attorney's fee records just as you
I provided all invoices in the 2015 case for legal invoices.
And is this matter in 2017 the first instance where the ORS has had an opportunity to review I-20 litigation costs?
No, it's not. I provided all I-20 litigations for the original hearing on April 3rd before then, as well as legal invoices regarding the same case in our 2015 rate proceeding.
And so has the ORS had a chance to review these Willoughby and Hafer costs and I-20 costs since 2015?
Yes.
And did the ORS recommend to this commission in 2015 that CWS get recovery of approximately $121,000 in I-20 litigation costs?
Yes.
And under what terms did the ORS recommend to this commission that Carolina Water Service recover I-20 litigation-related costs?
As part of a comprehensive settlement, they proposed an adjustment to remove the I-20 litigations from rate base, so we would not earn a return on the legal fees, but we were allowed to earn recovery of the legal expenses, and they proposed over 66 2/3 years, which is the same depreciation life on our assets. And as part of a settlement, Carolina Water Service accepted their recommendation.
In that case, in the 2015 case, how did Carolina Water request that these I-20 litigation costs to date be recovered?
In 2015, we proposed that they be included in rate base and amortized over 5 years.
And what is the difference between what Carolina Water asked for and what the Office of Regulatory Staff recommended?
ORS recommended that it not be included in rate base, which is typical of ORS to not allow deferred charges in rate base. And they also recommended that we amortize the expenses over 66 2/3 years.
And what was the Commission's order in this case with respect to these I-20 litigation costs?
They approved recovery of the cost over 66 2/3 years.
Just as they did in the 2015 case?
Correct.
No further questions, Mr. Chairman.
Thank you. Just for the record, I think your questioning did take a little longer than your setup. So, my granddaddy once said, "I wouldn't ever make any rash statements I can't back up." I understand. Any recross from any of the parties? Go right ahead.
Hey, hello there again, Mr. Carton. I want to go to, first I need to write down what it's spelled. In answering one of Commissioner Whitfield's questions, you had said that ORS says that sludge hauling will go away in the future, right?
Correct.
We're not asking, though, or we didn't put any evidence in this case suggesting that it's a zero number. Is that correct?
That's correct.
And going to, again, another follow-up to Commissioner Whitfield's questions, because he was asking you about normalization and what your opinion was on it. And you said again, and I think you've stated this before, that CWS's position is that sludge hauling is known and measurable and will continue, right?
Yes.
But again, why not normalize those costs? I mean, there's no dispute that there is some type of cost, at least currently.
Sure, it's just the cost that y'all are looking at, it's so far outside of the test year. You're referencing my charts of the most recent period available. It's February of this year. We filed the application in November of 2017.
But weren't those numbers updated at the request of the Public Service Committee?
They were.
Okay. And are you suggesting then, or is it your position that ORS should always just use test year numbers?
I'm not suggesting how ORS proposes testimony anyway. I'm just stating my position that our sludge hauling expenses were known and measurable during the test year. We provided the backup, and our sludge hauling expenses are going to continue as we move forward for the foreseeable future. And I was saying rates should be based on the test year.
Isn't it true, though, that pro forma adjustments, normalization, annualization, a lot of times work to the company's favor?
Sure.
Okay. But again, this time it's not working to your favor and you're opposed to it, correct?
Correct.
Okay, going to the questions Mr. Elliott was asking you regarding the invoice of 3516 that I had asked you about. Is it your position then, is it CWS's position that ORS auditors are supposed to cross-check every single line on these invoices to try and figure out who an attorney is and what case they're working on? Are we supposed to do that?
I'm not sure exactly what ORS's processes are for auditing, but I think what Mr. Elliott was showing was that it was possible to tie these invoices to work being performed on the case.
And who normally reviews these invoices for ORS? You've worked with us.
Correct. Yeah, I work very closely with Mr. Jasinski's audit team to provide invoices, and whenever they have questions or difficulty tying stuff, we typically go back and forth. I'll go over there and have face-to-face meetings with the audit group and try to provide as much information as I can to help them complete their audit.
So it's auditors or accountants that review these, not lawyers, right?
I'm not sure if lawyers at ORS review them or not, but I know that the auditors probably take the lead.
How many invoices were provided to ORS in this case regarding these legal fees? Do you have any idea?
I don't recall the exact amount.
Hundreds of pages?
Yes, sir.
And within those hundreds of pages, thousands of entries, I would guess, right?
Possibly.
But it's ORS's responsibility. It's your position that ORS is supposed to go through and check each one of those thousands of lines to see if we can verify what lawyer was working on what case.
I'm not doubting that it's a difficult task, but it's ORS's mission to audit and examine all costs of regulated utilities.
Isn't it the utilities' responsibility, though, to establish the veracity or their entitlement to recover expenses and plant?
It's
your responsibility, right? And what advantage, because the company is clearly taking the position here that the I-20 litigation, that the Congaree Riverkeepers lawsuit, the federal lawsuit, somehow provided a benefit to the ratepayers. Can you explain for the commission what that benefit for the ratepayers is?
I'll defer that question to witness Babcock.
That's all the questions I got. Thank you.
Thank you, Mr. Nelson.
Thank you. Okay. Mr. Carton, I think we've come to the end of your time at the table, so you may step down.
Thank you, Chairman and members of the Commission.
present your next witness. While Mr. Hunter's coming up, I'll tell you we're going to go till around the noon hour before we'll break for lunch. So just to have that in your mind.
It's going to go at 100 tomorrow.
My name is Robert Hunter.
And who are you employed by, and what do you do, Mr. Hunter?
Employed by Carolina Water and the financial planning and analysis manager.
How long have you worked there?
5 years this month.
There are 7 pages pre-filed direct testimony and one exhibit DR-RMH1 in connection with this case.
Yes.
Do you have any additions or corrections that you would like to make to this to your testimony?
I do not.
Or the exhibit?
No.
If I were to ask you the questions in the pre-filed testimony today verbally while you were on the stand, would your answers be the same?
Yes.
Mr. Chairman, I would move to introduce the pre-filed direct testimony of Robert Hunter into the record at this time.
Okay, the direct pre-filed testimony of Mr. Robert Hunter will be read into the record as if given orally from the stand.
Mr. Hunter, did you prepare or cause to be prepared 6 pages of pre-filed rebuttal testimony in this case?
Yes.
Do you have any corrections or additions you wish to make to your rebuttal testimony?
No.
Mr. Chairman, at this time, Mr. Hunter, if I were to ask you the questions in your rebuttal testimony today, would your answers be the same?
Yes.
Mr. Chairman, I would move the introduction of 6 pages of pre-filed rebuttal testimony of Robert Hunter into the record at this time.
Okay, Robert Hunter's pre-filed rebuttal testimony will be read into the record as given orally from the stand.
Mr. Hunter, please tell the Commission your duties with CWS.
I'm responsible for...
Hang on 1 second. You want to go ahead and get the exhibits in?
I thought I did.
We missed that
well,
part.
I'd like to, Mr. Chairman,
You did it very quick.
I did. I slipped it in. I would like to introduce Exhibit DR-RMH1 into the record.
Okay, the DR-RMH1 will be entered into the record as Exhibit number 3.
Yes, sir. I apologize.
Now, continue.
Okay. Mr. Hunter, you were going to tell the Commission about your duties for Carolina Water Service.
Yes, so I'm responsible for all of the accounting and financial aspects for the South Carolina business unit here for Carolina Water, which includes forecasting, budgeting, variance analysis, putting together the filing for the rate application.
And what's your educational background? There are a couple of commissioners that haven't mentioned yet. I'm not going to belabor this, but tell them a little bit about yourself.
I studied at the University of Illinois in Champaign-Urbana, and I got a bachelor's in general management and corporate finance.
Okay, thank you. And you said your duties involve rate design.
Correct.
Were you involved in designing the rate structure for the CWS case that was before the commission now?
Yes, I was.
Can you describe, and I've put a chart up there that's just a demonstrative exhibit. Can you describe the rate structure using that chart for the commission?
Yes, so the two service territories that are displayed on the chart are for water. So we have two water service territories, Territory 1 and Territory 2. Within each of those service territories, we have two sets of customers: water supply customers, which receive water supplied from wells that are owned and operated by Carolina Water, and as well as distribution customers, which are customers that where water is purchased purchased for distribution and resale by Carolina Water from government agencies or other entities. So within each of those service territories, each of those customers pay a base facilities charge, which is a flat rate, as well as a commodity charge, which depends on the usage.
And is the basic facilities charge, you've got two service territories. Why do we have two service territories?
So as prior to the last rate case, when we consolidated the four previous entities, which were Southland Utilities, Utility Service South Carolina, and United Utilities, into Carolina Water. In the prior case in 2015, we went through and combined some of those companies that made sense based on the current rate structures going in. And so we ended up combining the former Carolina Water and the former Southland together into Water Service Territory 1, as well as the Utility Services of South Carolina and United Utilities into Service Territory 2.
And within the service territories, the basic facilities charges appear to be the same.
Yes, so within either service territory, the base facility charge will be the same for supply and distribution customers.
But the commodity charges are not?
Correct.
And why is that?
The commodity charge for distribution customers specifically will be dependent on the actual purchased expense we have. So in this case, for example, the West Columbia increase for purchased water would contribute to the commodity charge for the distribution customers in both service territories going up.
And just to round out the chart, you have two columns there with two sets of rates. What are they? You have Order 215-876. Was that the 2015 order, Mr. Hunter?
Correct. That is from the prior case.
The prior case's rates. And then the ones on the right are the rates from this case.
Correct.
Right? Okay. Has the commission previously approved rates for a two-service territory structure?
Yes.
And it did that in 2015?
Yes, in the prior case.
Okay. How do you arrive at the rate design for each of the service territories?
So at a very high level, it starts off by just taking the financials for the test year. So we pull the financials together for each of the companies that end up rolling up into these service territories. So once we have the financials, we apply any known and measurable adjustments using the ORS audit through that process between just to get the application set up. And then once we do that, we look at what the cost of service is and what the resulting revenue requirement is in order to reach the allowed ROE, or return on equity. And so once we have that revenue requirement number for any given service territory, I look at the rates from the prior case that were approved, apply a percentage increase to get to the new rates in order to produce enough revenues to meet that revenue requirement for that service territory.
Okay. And you submitted an exhibit, DRMH1, to the commission with your testimony, and it was on a flash drive. What was that exhibit?
That exhibit is the actual Excel file or workbook that I used to create the application. It contains approximately 100 tabs, and it all flows together, taking the financial data, rolling up as I was stating for how we get the revenue requirement, and ultimately producing the final rates that you see.
Okay. Mr. Hunter, rates, why are the rates different from one service territory to another in this case?
So as I mentioned, when we're putting it together, we're looking at the financials for each of the companies. So each service territory has different costs, different rate base, different number of customers, different usage. So there's a lot of different variables within each service territory. And so that revenue requirement is very specific to that service territory. So ultimately, the rates to get to that revenue requirement are going to be different based on those variables.
And did you use this method to calculate the rates that were applied for by the company?
Yes.
And did you use the same method in preparing rates that were submitted with the proposed order?
Yes.
Okay. The rates that were submitted with the proposed order were different than the ones that were applied for, I suppose.
Correct.
Right? And why is that?
So between the application and the proposed order, we obviously went through and reviewed all of ORS adjustments. We agreed with numerous adjustments and applied those to the application filing. So ultimately that results in different cost of service for each of those service territories. The numbers change, the resulting revenue requirement changes, thus the rates change.
Do you remember approximately how many adjustments there were?
Not off the top of my head.
What were the biggest movers?
So a couple that come to the top of my head are one that affected all of the service territories would be the Tax Cuts and Jobs Act. So there was a significant impact from that was not applied in the application. So between the application and the proposed order, we adjusted all the service territories for that. So that lowered the rates. And then specifically another example that didn't impact the total revenue requirement, but would have impacted the cost of service between service territories, was an adjustment for property taxes. And just a little background, during the ORS audit review, we found that there were certain property tax amounts that were in the application assigned to Service Territory 1, but ORS audited it, and we found and agreed that some of those portion of that cost, was approximately $400,000, should have been attributed to the sewer service territory. And so they made the adjustment to move that revenue, or the revenue required, but the property taxes from that territory into the wastewater territory. So ultimately that changes the revenue requirement between those two. And that'd be one where you're taking it out of Territory 1, thus lowering the revenue requirement and lowering rates.
Does the way you calculate rates for these two service territories result in any subsidy from one to the other?
No. It's based on their own cost of service for each territory.
Do you believe this is a method or a rate design that the Commission should adopt?
I do.
And at the hearing last spring, you didn't provide rates to the Commission at the hearing. You only provided them after the hearing. Why was that?
So typically, in the cases where it's contested, there are numerous adjustments that are still being disputed, and the final cost of service or the final expenses or any of whatever you name the adjustment isn't known yet. So at that point of time during the hearing, to give rates would just be an estimate. It wouldn't be known, it wouldn't be final, and it was not specifically asked at that time to give any estimate of what the rates were.
Let's talk about amortization of the rate case expenses. Mr. Carton touched on it earlier, but I'm just going to ask you, just in a sentence, can you summarize how the rate case expenses were to be recovered in the Commission's last order?
Or in the rate case expense or the...
I'm sorry, I keep saying that litigation expenses, I mean.
Yeah, so the litigation expenses in the prior case were agreed to be recovered over 66 2/3 years. So in this case, I proposed the same treatment of those litigation expenses.
Were there any carrying costs on this money?
No, in the last case, they were removed from rate base, so there wouldn't be any. You're not earning a return on.
If the company were to earn a return, do you know what it would be?
Or if they were included in rate base, there would be approximately, double check my number, approximately $118,000 in revenue requirement. Mm-hmm. They were included as part of rate base.
$118,000 total or per year?
It would be $118,000 in revenue requirement, so that would be per year.
But that is not being sought, or it wasn't ordered?
No, sir.
Okay. If we were to shorten that amortization period from 66 years to, say, 30, what would the consequences be for the company?
So by shortening the amortization period, the amortization expense would go up, which is part of the revenue requirement ultimately, because that's the cost per year. So ultimately, expenses would go up per year, revenue requirement would go up, and the customer's rates would be higher with a shorter period.
But what about the company? What would happen for the company?
The company would earn more revenue in a given year.
And it would,
It would recover their expenses quicker.
yeah. So does a shorter amortization period favor the customer or the company?
The company.
Have you ever encountered an amortization period longer than 66.67 years with no carrying cost?
Not in my experience.
Thank you, Mr. Please answer any questions the commission or the parties may have.
Thank you, Mr. Torini. Ms. Valtorta. Mr. Knowlton. Okay. Mr. Nelson.
Morning, Mr. Hunter.
Good morning.
Still morning here. Yeah, it's been argued, I think, both by you as well as Mr. Carton, that regarding the I-20 system attorney's fees, that it's CWS's position that ORS and the commission are bound by the settlement in the 2015 case. Isn't that what y'all are saying?
I'm going off of what was approved in the prior case.
I'm going to pass you something. This is the order of the Public Service Commission, order number 2015-876.
Yes, sir. Get to your microphone there, Mr. Torini. Mr. Nelson, we need you at the microphone too. Okay, I think we're good.
Can you read paragraph 13, please, of the commission's order? And this is the settlement agreement attached to the order. I should clarify that.
The parties agree that signing this settlement agreement will not constrain, inhibit, or impair in any way the arguments or positions they may choose to make in future commission proceedings. If the commission should decline to approve the settlement agreement in its entirety, then any party desiring to do so may withdraw from the settlement agreement without penalty.
So that's basically saying the parties aren't bound by that agreement, right? By the terms of that agreement.
That's fair.
That would include the 66-year amortization period, correct?
Agreed.
Okay. What if, and Mr. Trini made the point, asking you questions, that this long amortization period means less money now for the ratepayers, but it's spread over a much longer period of time too, right?
Correct.
So this would end in the year 2084, is that right?
Sounds
more or less?
right.
Okay. How much, if you took that, what's a typical amortization period for most of your plant?
66 and 2/3 years.
Okay. What if we had like a 20-year? Do you have any idea what the effect would be if we're using legal fees for a 20? I mean, this isn't plant, right? This isn't something that's pipe in the ground or an operating plant. These are legal fees. What if we cut this back and had like a 20-year amortization? Do you have any idea what the effect on the rates would be?
Not the ultimate effect on the rates. I don't have that exact dollar amount.
Okay. But it'd probably be pretty significant, wouldn't it?
It would be higher than it currently is at 66 and 2/3 years.
Yeah. And it'd probably be noticed by the ratepayers a lot more in that case, wouldn't it?
Yes, with the higher rates.
I want to ask you something too, and this goes to page 3 of 6 of your page 3 of 6 of your rebuttal testimony, and the sentence starting at line 2. Are you there yet? I'm going to make sure you see it.
Yes.
Okay.
Yes.
And in this portion of your testimony, you stated that during the audit process, ORS identified property tax bills that in the application had been fully allocated to Water Service Territory 1. In fact, didn't ORS then provide information after the initial order was filed in this case to provide that information to the company?
You repeat the question?
Sure. Wasn't this something that was found as far as a correction to the need to correct the appropriate assignment of property taxes?
Yes.
Okay. All right. So that was something that occurred after After the order of the commission was filed, right?
No,
Okay, when did that happen?
during the audit process
Okay, during the audit process of this?
of the
I want to mix it up.
the regular
The original
hearing.
one.
Yeah,
Okay.
the original
all right.
hearing.
Okay. Yep, that's all I need. Thank you very much, Mr. Hunter.
Thank you.
Thank you, Commissioners. Commissioner Urban.
Question for the witness. Mr. Hunter, how are you today, sir?
Good. How are you?
Great. On page 6 of your rehearing direct testimony, you state that eventually the company would like all of its water customers to pay the same rate, but it may take some time to achieve this goal. Could you give us some idea about what the company's plan is to more closely align the rates?
Yeah. So ultimately, when we consolidated the companies, our goal was to eventually get to that point where we have one rate, make it simplified. All water customers are on the same rate, similar to how our wastewater is set up. But it's something that each rate case we continually monitor. So going into each case, we will always evaluate every option, whether it's consolidating one rate or consolidating all the rates. This is something we review going into every rate case. And it's impossible to really say at this point exactly when that'll align perfectly. But as I said, it's something we look into every single rate case and weigh all the options.
What would be the water rate in this case if a single rate was charged?
I don't have that offhand, but I could get it.
You think it might be helpful to the company to have kind of an outline in terms of, or a timeline in terms of how to unify the rate structure for these two territories?
It's tough just with how it's tough to really predict how the costs are going to go. I mean, that's really the main variable. Obviously, we don't know what all the expenses will be in the future, or what every capital improvement will be, where it'll be. So it's tough to really align that perfectly.
Are there potential savings out there that where one vendor or provider could serve one unit as opposed to two separate units?
I think there would definitely be efficiencies as far as you mentioned, just easy for the vendors to identify. There might be some efficiencies to gain there. It would also help with our billing department and complaints, just being able to more easily identify what the rates are, lessen that customer confusion. I think there's definitely benefits both. You can actually see it.
I would encourage the company to consider that going forward. I think it would be helpful to the ratepayers and to the company, frankly, to have them all on one rate going forward at some point.
Agreed.
Thank you.
Thank you, Commissioner Urban. Do you want a late filed exhibit on the question that you asked about rates?
If we could get that, I would appreciate it. You said you could give us an answer on the what the rate would be.
I could calculate it, yes.
Yeah, that'd be great.
Okay, we'll make that exhibit number 4, late filed exhibit.
Thank you.
Okay. Mr. Hunter, what was the book value of the I-20 plant before condemnation? You know?
Off the top of my head, I know I don't know exactly off the top of my head.
Okay. All right. Why don't we see if we can get that too as a late file and the fair market value that it will be.
Will do.
Yeah. That'll be exhibit number 5. All right, any redirect?
Commissioner Randall, your request for a late filed exhibit, we certainly don't have a problem providing the book value. The fair market value I'm not sure we have that. I mean, it's an issue in the condemnation case right now. We do have an appraisal. Okay, we'll have it for you.
Right. Thank you. Okay, before we go to redirect, Commissioner Whitfield's got a question.
Mr. Hunter, I got one kind of follow up with where Commissioner Irvin was going, talking about the two territories. And I remember when they were 4 or 5, they were all separate. And for years, the studies were done, and it finally happened about 3 years ago. My question to you is, you were talking about the Territory 1, Territory 2. You got the old USSC and the old United Utilities in one, and Southland and CWS, Carolina Water Service, in the other. You made a comment earlier here on the stand today about you, and I know you said neither territory subsidizes the other, but you made a comment about pulling financials on the 4 different companies. Are you still keeping, even though the 2 have been consolidated into Territory 2 and 2 have been consolidated into Territory 1, are you still kind of keeping things separate, even though they're identified for purposes in South Carolina all as CWS, Carolina Water Service? Or how are you, from a bookkeeping standpoint, keeping up with that?
Yes, so in our legacy system, for our accounting legacy system, the coding or the identifier for those companies still remains as 4 separate companies. And so whenever I'm putting together any application or that, I'm just rolling those up into the service territories. So it's just in our legacy system, that's still the way the coding has them in there as.
I see. So back to the question, it's come out again today that no one territory is subsidizing the other, and just want to have you touch on that again a second, because there, in the past, particularly at night hearings from public witnesses and from others, there have been some questions. I stopped short of using the word allegations of one territory or area subsidizing, if you will, another. And of course, you've made references to different numbers of customers, different pools of customers, different population densities, everything. So if you could just touch on that for a second.
Yes. So as I mentioned, so Service Territory 1 consists of the former Carolina Water Service and Southland, so 400 and 402. And those customers, all of their costs in the rate case are cost directly coded and assigned to those companies. So when we're doing the rate design, when we're doing the filing, everything that's service territory is directly for those customers. So in that sense, they're not subsidizing other customers. The USSC and the United are on the service territory too, and all of their financials, expenses, capital expenditures are all going to those companies and to service territory 2 specifically. So in that sense, both service territories are based on their specific cost allocated and assigned to those companies. So they're not subsidizing the other territory.
Not bearing on this case before us today, but what Commissioner Irvin mentioned, if you were to combine them ultimately into one territory, which has been, of course, talked about in the past, how do you think the company could do that in a fair and equitable way?
And that's what's to be determined. That's why we always evaluate it, and why we haven't just gone to one single rate immediately, is we want to make sure that it makes sense and that the rates align. And until we get to that point where combining them makes sense, and that for all the customers, that there's not a massive swing in either a rate decrease or a rate increase for any single customer class. So it's tough to say without knowing at the exact point in the future, when we analyze that and look at the actual cost of service at that point in time, how that'll actually fall out.
Thank you. Thank you, Mr. Hunter. Thank you, Mr. Chairman.
Thank you, sir. All right, Mr. Terraney, any redirect? Good answer. Any recross? No, that was no I'm still a rookie at this, so no redirect, no recross. It's a learning experience for me, too. We're going to break. Oh, yeah, you can step down.
Thank you, Commissioners.
We're going to break for lunch. We will be back. We'll reconvene at 1:21. We are adjourned.
I like that, Randy.